Okay, hello everyone. Good morning, good afternoon, good evening, and welcome to SIT Insights in IP and Law. Let's get started. Why don't we move on to the next slide, please? So SIT is an interdisciplinary ecosystem where our goal is to push and challenge our students and researchers to be leaders and entrepreneurs. So leadership and management skills are at the core of our courses and our ethos. And therefore, this is the very first of a series of webinars that SIT has created, which we will be releasing on a quarterly basis to touch upon business matters that are of essential value to companies, founders, and future founders. Let's move on, please, to the next slide. So my name is Katja Fischer. I am a New York licensed attorney. I'm head of legal to the chairman of SIT. For the past year, I've had the distinct honor and pleasure of working with the team at Schaffhausen Institute of Technology and supervising legal matters in 8 countries and counting on a variety of different issues. I'm very pleased to be here, very excited to speak with all of you, and I'm also very honored to have Nadia Kashingo joining us today. She is the CEO and founder of ESPE Consulting Group and a preeminent authority in the fields of intellectual property law, data privacy, and patents. Let's move on. So with regard to the SIT ecosystem, what is SIT? At SIT, we are driving technology and education business in order to generate unconstrained funding and other value needed for science. We offer master and PhD programs and are building various research programs and institutes, which will generate reputation for SIT, people, knowledge, intellectual property, and services, which we may then bring into the commercial part of SIT, which includes some of the projects that you see here today, including SIT Academy, Alamira, SIT Autonomous, SIT Programming School, and SIT Start Garden, which in turn will develop funding services and technology needed to service our educational programs and also to generate new businesses, new companies, and new leaders. This is what comprises what we refer to as the SIT zone. The SIT zone is headquartered in Schaffhausen, Switzerland, but we are global. We are building a presence in countries worldwide, as well as a virtual presence. SIT focuses on computers, physics, and business management, and provides an interdisciplinary approach because we believe that modern problems need an interdisciplinary approach in order to find strong, healthy solutions. Let's move on, please. So I will get started with my portion of this discussion, which is key legal considerations for startups in the new global economy. May we move on to the next slide, please? Okay, so the world is changing very rapidly. Thanks to technology, thanks to events such as COVID-19, companies are working in an international context like never before. If I were giving this type of talk 10 years ago, 5 years ago, I would be thinking about things from a very different paradigm. But now we tend to work in this globalized context, and people are working with each other around the world, around the clock, different time zones, different countries, different languages. And it feels as if we've become this very globalized society and borders no longer matter. Unfortunately, however, borders do exist, and laws have not caught up to the new reality. Laws are still, generally speaking, country-specific, and therefore, the laws that may apply to your company and to your business in one country may be completely different in another country. And sometimes there are major differences, and sometimes there are minor differences and minor nuances that can make a big difference and can have a tremendous impact on your business. Something else to keep in mind is because of globalization, because of the internet, because we're so impacted and affected by one another in this day and age, we're also dealing with the fact that the laws of another country may end up impacting your business even if you don't conduct any business in that country. So for example, GDPR, data privacy, which Nadia will talk about a bit later, is something that countries have to deal with even if the country that you're in isn't necessarily subject to the GDPR. Navigating multiple jurisdictions is a highly complex area. Most lawyers and other advisors are specialists, they're not generalists. This makes sense. Law is extremely complicated. Law is extremely difficult. There are many areas of law: corporate law, tax, intellectual property, employment law. Not to mention the fact that everything, again, is country specific, and lawyers have to study the laws of their country and become licensed in the countries where they practice. But that means that for founders have to be keenly aware of this and understand that you really need to start by having this generalist approach and looking at things from a bird's eye perspective in order to then work with those specialists and maximize the value that they're able to provide to your business. So part of the goal of today is just giving a little bit of a sense of the types of things that a founder might want to think about in terms of legal issues, whereby in order to become a really great founder, you want to make sure that you're able to talk the talk and understand the language of lawyers and understand legal issues. And you might not become as specifically knowledgeable in an area as your lawyer, but you certainly want to become smart enough and educated enough in these fields to really understand what it is that your lawyers are telling you and to be able to navigate through all of these issues. Let's move on to the next slide, please. So the first question that founders always ask is, where should I incorporate my business, and what type of corporate form, what type of entity should I register my business as? There is no magic bullet answer. There is no magical offshore jurisdiction that will solve all of your problems and make all of your dreams come true. Instead, there are multiple jurisdictions around the world that may or may not be a great idea for your company. So these are the questions that you want to ask yourself, and obviously you want to discuss with your legal counsel. The first question is, what is the best interest of the founders and where are they located? So if you are living, for example, in Switzerland and your partner is living in Switzerland, there may be a strong argument for forming your entity in Switzerland because that's where you are going to be present, that's where you're creating substance, that's where you're going to actually be actively running your business. If, however, you are located, let's say in Switzerland, and your partner is located in France or in the United States, you might want to take a look and think about future planning and think about the ways in which incorporation is going to affect your business and you on a personal level from a tax perspective, and also in terms of where you might end up living, where you might end up conducting most of your affairs. The next question that you're going to ask is, what is in the best interest of the investors and where are they located? So this has to do not only with investors, but also where value can be generated. So for example, if you are looking to join a startup accelerator program, it is highly likely that the Startup Accelerator program will have its own requirements with respect to where you should be forming your company. There are a lot of venture funds that have mandates whereby they will only invest in companies that are organized and registered in certain countries in the world. Chances are that if you are registering your entity in a country like the United States, Switzerland, Singapore, you will have a better chance of meeting the requirements and mandates of many of these venture funds than if you are registered in a smaller, more lesser known country. So that becomes a question. In addition, like I said, with accelerator programs, you want to think not only about money, but also value. where you're getting the best advice, where you're getting the best assistance, where you're getting the best support, where you're getting the best access to human capital. So that might be a consideration as well. And then last but not least, individual investors might have their own requirements based on what they're comfortable with and also based on their own tax planning. So this becomes an issue that you'd want to take a look at. And number three is just where are the customers and clients located? So where your customers and clients are, in all likelihood, is where you're going to have a presence, whether that's where your main holding company is going to be located or where you might have to open up a subsidiary office eventually at some point. But that's something to take into consideration as well. In terms of what type of company you want to form, you may have heard about corporations, limited liability companies, partnerships. In other countries, there are other terms: limited company, GmbH, AG, OOO. It becomes extremely overwhelming and extremely confusing. And a lot of times people will discuss the differences in terms of taxation, the differences in terms of cost in organizing these types of entities. A very simple way to think about it, if you're a founder, is if you are interested in eventually entering capital markets, you're going to want to register and form yourself as a corporation. So by capital markets, I mean if you have a dream that one day, many years from now, your company might have the opportunity to conduct an initial public offering and go onto the stock market, there are very simple corporate formats that need to be followed. However, if you're opening up a consulting company or an investment company, there might be other considerations involved. So generally speaking, I would say for most of you, it's going to be a corporation, but this is the way that you would want to think about it. Let's move on to the next slide, please. Okay, so the next question is going to be with regard to founding agreements and the relationship that you want to have with your founders and partners. So the first thing, obviously, is if you're starting a business with a co-founder, you want to have a very clear understanding around roles and responsibilities up front, and you want to be as transparent as possible in terms of your expectations of one another. In terms of equity ownership investing, you need to allocate the ownership of your new enterprise amongst the founding team. Normally, you will set aside about 90% in the beginning because you want to set aside at least a 10% option pool for your future hires. And then you want to figure out what pieces of the pie you're going to be giving amongst yourselves. And this is before we even take a look at investors and venture capital and the like. Something that you want to think about is market vesting terms. What that means is that each founder has to earn his or her equity by contributing to building value in the business. So usually that means that the longer you spend as part of the company and an active member, the more equity you are able to build for yourself. And this becomes very important because something that's a very common issue is that two people will decide to start a company together. They'll contribute the same amount of minimal capital, they'll contribute everything the same, they'll decide that they're 50-50, and then 1 month later, one partner starts getting very upset that the other partner isn't pulling his weight. And then 2 months later, that partner who wasn't pulling his weight decides that this isn't really the right project for him, and he leaves and he takes 50% of the company with him, which means that the remaining founder has a much smaller equity pool to play with when bringing in other founders, investors, and the like. So you don't want to dilute yourself out from the get-go. Lastly, the company lawyer is not your personal lawyer. So seek out independent counsel. I can't stress this enough. Obviously, if there's one lawyer who is assigned to handle all the matters for the company, that lawyer, generally speaking, will have the best interests of the various founders at heart and will want to make sure that things go smoothly. But there is still something to be said about having your own lawyer. Just take a look at your portion and your roles and responsibilities and your contract when starting a company. Let's move on, please. Okay, next, employment law. So this is usually the next big one. You want to understand some of the basic tenets of employment law. I have found in my experience, having dealt with employment law in many countries, that most of the tenets are pretty much the same, even if there are some variations in different countries. So the first thing that I can't stress enough, and I talk about it all the time, is learn the difference between an employee and an independent contractor. Employee and independent contractor, these terms are not defined by virtue of the fact that you write employee or independent contractor in a document. What determines whether or not someone is an employee or whether or not someone is an outside contractor is the means and method of control. So if somebody is truly an outside independent contractor, that person is in business for him or herself, that person is an advisor to your company, that person is setting his or her own hours, own rate of pay, and you are contracting with that individual. If somebody is an employee, you as the employer are determining all of the rules for that employee. What the pay is, what the hours are, what the work is going to be, what the reporting requirements are, and you have higher expectations that that individual is really going to be focusing all of his or her energy on your business. So that becomes really important because obviously you want to make sure that you're following the laws in every country. And if you take a look at the news, this has become a really big issue for some major corporations, especially in the United States in the past few years. You definitely want to take a look at local labor laws. If you can't afford an outside employment lawyer and you don't have in-house HR, definitely talk with a professional services firm that provides payroll processing services. Usually what's really great about payroll processing companies is they often can supply you with employee handbooks and they can often guide you with respect to employment regulations in the country where you've set up payroll. So take advantage of that and always ask. Checklist of some of the things you want to take a look at are obviously employee handbook, employment agreement, confidentiality terms, non-compete and non-circumvention terms, and also the level of protection that you can reasonably expect in the country where you're entering into such provisions, IP assignment agreements, data privacy policies for the company, media policy. This is incredibly important. You want to make sure that the people who are working for your company know what the rules are with respect to social media, with respect to talking to the press, and any incentive plans. And lastly, you want to consult a lawyer before terminating an employee or making any significant changes to employment agreements. Let's move on, please. So a few further international considerations to keep in mind as you navigate through our new global paradigm. One is business immigration. So again, country specific. Every single country has its own laws, own regulations surrounding visas and the types of visas that one may expect to be able to apply for. So generally speaking, most countries have opportunities for top executives and managers. So there are a lot of opportunities for example, intra-company transferees. So if you have your startup in one location and it becomes robust and has employees and is active, and then you want to go ahead and set up another office, there are usually specific types of visas for that. There are opportunities most frequently for very high level talent, so people who are of extraordinary ability or people who have really reached the top of their career. Next, for investors, obviously there are investment visas that are available in many countries around the world as well. Usually the minimums can really vary, but quite frequently it's usually if an investor has about $1 million and a strong business plan. There are many countries that will accept that type of application. And lastly, entrepreneurs. There are some countries that offer startup visas, not all countries. The last consideration that I would highly encourage any founder to keep in mind has to do with international taxation and just taxation in general. So I highly recommend to familiarize yourself with corporate tax issues, capital gains, VAT, which becomes a major issue, particularly if your company is based in Europe or is doing business in Europe. Sales tax in the United States, sales tax is actually governed state by state, so that can become extremely particular. So sometimes you really need to find somebody who has specific expertise with sales tax. Royalty income, so again, back to intellectual property, which Nadia will discuss a little bit further. There can be specific tax rates around royalties and around IP. There are some countries that offer specific incentives like patent boxes or IP boxes, so that's something that you want to take a look at as well. And lastly, personal income tax, because the tax status of you as a founder, the tax status of your investors will ultimately come into play when considering, again, where to do business, how to do business, and how to structure your startup overall. So that's it on my end. Thank you all very much. Again, I highly recommend just to think a little bit about these different areas. And now let's move on over to Nadia Kashingo, who will talk about intellectual property, patents, and data privacy. Nadia, thank you so much for joining us today. I would love for you to tell us all a little bit about yourself and your experience and background.
All right, thank you very much, Katya, for your interesting presentation. Yes, and I will speak about intellectual property now. There are multiple interesting topics here, and this is my passion. And for startups, I try to select the most useful ones for our webinar. Please, next slide. I'll have 20 minutes for my part. And the topic here today is I'm setting up an IT startup. I think about intellectual property rights and data privacy. Okay, next please. And before we start, I will introduce myself. Now I'm CEO and founder of ESPE Consulting Group. Welcome to visit our website. I have master's degree in computer science. Also, I have LLM degree, and I have also status of patent attorney. Next slide, please. In my career, I had very interesting cases in the United States, 10 lawsuits. We succeeded there. And also 2 successful antitrust cases with the global effect against Microsoft and Apple. You know that digital market does not have any borders, so that we confirmed their dominant position and abuse the dominant position on the market. These 2 companies created barriers for other companies and created privileges for their products. That can be very relevant to the startups, and we saw how companies appeared on the market and just was pushed out by these global tech companies. So what to do if you face with the problems when you have your product for platform of Microsoft or Apple, and if you have some issues there, please let us know and we will try to help you with this. So about patenting, patents are very interesting to do. So I had 1,500 patent applications filed, and 1,000 patents were granted. And I'm co-author of 14 patents on cybersecurity. Before I became patent attorney, I invented some sort of things. Next slide, please. So, and okay, what to think about? First of all, we need to understand what are the IP rights. IP rights are the rights given to persons over the creations of their minds. Can you imagine that? They usually give the creator an exclusive right over the use of his creation for a certain period of time. For example, you created an idea, some technology, and you have patent. So you patented this idea. What will this mean for you? You will have exclusive rights for the next 20 years for this technology, and then it will come to the public domain. Patents are territorial, and you need to apply for the patents in every territory where you want to have this protection. Copyright, when you write the program, it's like you write a book, and you have your rights, copyrights, once you have this done. Trademarks are the same like patents. You need to apply in every country. That's also important. So we understand there are the rights, okay? Patents, copyrights, what to do with all these. And that might be a question from your side that, for example, I can implement the idea in different languages. For example, I'm a former programmer and I used to use the languages like C++, C, assembler, etc. So I can create the idea and implement this in different languages. That means that I will have different copyright products. But I implemented one and the same idea. And now you see what I mean, that your competitor can implement the same idea, but in different language. And this will mean that there will be no copyright infringement, but that can be possible patent infringement if you patented your idea. So I hope that's clear. And you understand why we need to have these patents. And what to do? Competitive disposition on the market. You need to understand who are the competitors, what are their rights. When we create materials, software, new technology, logo, etc., what's going on in terms of the rights. So if you have third-party code or any third-party IP in your product, work product, do you need to follow and meet the requirements from other right holder? Yes, that's definitely mandatory. So if you have third-party code and include this code into your product, you need to have the list of third-party code that you used for the product. And this is the best practice, and this is obligatory to do that. And even if you have, for example, picture or sound for your presentation, and this is third-party product, and then I will make a level up for you. So if you use smell during your presentation and smell was patented, this is a chemical formula, and you just spread out the smell in audience, and that's very good. But that can be associated with the right holder, and right holder didn't provide you any rights for that, or you infringed the patents and you just copied and make similar and with the same elements of the smell, that also can be considered as the infringement. But I haven't had in my experience any analysis with smells, but I like this idea and topic, and that's easily to deliver to the audience how it works. And you need to understand that intellectual property rights are everywhere, everywhere. Therefore, I provided to you the example that is something about your minds. Everything as a work product, everything you do, that is your intellectual property product and intellectual work product. Okay, so rights should belong to the company. How to ensure this? Sometimes I met the situation when the potential employee comes and say that, I have an idea and implemented that, and I will include this into my current project if you have me on your team. But no, the answer is no. You don't need to have any problems with the previous employer, and you need to understand that is like normal material property which should belong to the proper right holder. And if you hire employee, they need to work carefully with third-party products and third-party rights. So for that, you will need to have IP policy, you will need to have instructions for your people, you will need to have a separate specific paragraphs in the employee agreements, etc. Data privacy. So if you are IT startup, if you have a service and you have distributed architecture, for example, and you process data of the customers, and you do transferring of these data, here should be policies, not only the privacy policies, but also retention policy. Then you need to have sort of passport, how you deal with the data in your organization, who is responsible for that. who has access to the data, and you need to comply with all laws. For example, from my practice, I dealt with 180 countries in terms of compliance for intellectual property and data privacy, and there lots of questions we had with CCPA, with GDPR, with LGPD, which is Brazilian GDPR, so and many other laws. So, as for the target, just keep in mind that GDPR is the strictest law. This is exterritorial that Katya mentioned, exterritorial law. And even if you are not in Europe, if you're, for example, in the United States, but your customers are from Europe, then you need to comply with GDPR as well. That means that is exterritorial law. Then there are many more other topics, but if you remember at least these things, that I think that for your startup is a good start. Okay, next slide, please. Why do I need patenting? Very good question. And here I will speak about innovation product. Of course, all companies prefer to tell about innovations, but when you speak about innovation, if you say that my technology is innovative, we are the first, etc., etc., so that could be a competition in terms of false advertisement if that is not innovation. Okay, so innovation can be for your company, but not for the market. That is very principal thing. And when you see advertisement like we are number one, there should be a reference to third-party source where they admitted that you are number one, where, under what conditions, under what circumstances, etc. So be very careful about innovations, because that's very sensitive, and that's very really that's not a rare situation when there are the question can come up with the wording of innovation product. So with patenting, you will have investment attractiveness. Then you will understand that will get protection on the territory where you applied for the patent. Of course, this is intangible asset, capitalization, tax benefits, tax relaxation can be here. Oh, and here I would like to touch the topic about defense. So rights, patent rights are the protection, but defense is a different thing. So many companies really think that if they have patents, then they have a good defense. Why others write them letter about possible infringements of the rights? Because the technologies were patented. No, that's definitely wrong understanding. I will provide you a very simple example with black and white TV and colored TV. You know, this is technological progress. When you do innovation step with and adding colors and have colored TV now, this means that you will have patent for this innovation, but it doesn't mean that you can avoid infringement for all technologies that was patented before in previous eras. And here that is the same thing, that you can add something, some innovative step to the technology and get the patent, but at the same time the technology can possibly infringe others' rights and previous patents. Hope this quick explanation will help you, and you will understand that defense and protection mean different things. Okay, next slide, please. And scope of the protection, what can we protect with the patents? If we have systems and methods can be protected as algorithm, as invention. Then we will have systems, which is apparatus that can be protected with invention and utility models. graphical interface as industrial design. For example, you remember there is a Coca-Cola design, and they patented their industrial design, or website that is graphical interface also can be registered as the industrial design. And very important thing is that promptness of patenting can provide the necessary amount of protection. Next slide, please. Next slide, yes. What to do? So if you enter the market, there can be the risks of possible infringement of third-party rights. I just shared with you my thoughts, and I hope that you understood what I meant to say. So you need to understand who are your competitors. You need to conduct this research, of course. When you appear first time, you can be very sweet, easy target for others, you know, and you need to be prepared on the market. What distinguishes from competitors? What is your innovations? Yeah, what is your innovation step? You need to understand whether or not you just repeat others, and then you can have possible infringements and possible problems on the market. So there are multiple things that you need to understand when you start. And where in which countries do you distribute your product? And you remember that the rights are for patents, trademarks, applicable in every territory. You need to apply for the rights in every territory where you have business. And there are some malpractices in the territories. For example, if someone understands that you are going to enter other markets next year, they can register trademark before you, and then there will be a battle about transferring the rights, etc., etc. So you need to think beforehand which countries are your priorities, and then you will save your time, efforts, money, everything. So are there in product development plans? If you have plans, that's very good. I always ask about plans, and usually people, 80% actually, have their plans for the next 2 years. But what I ask to have, please imagine that you don't have any obstacles. Just imagine yourself in 10 years or 15 years. That's hard, but then you will understand how to develop, what other trends could be, and you will understand and can make future innovations. And that means that when you apply for the patent rights, you will not consider only the current ideas that you have in your products, but you will do these innovations, and you will add this global innovative step. So that, you know, it's like a child. When child, because kids, they don't have any borders, you know, they can fall on the floor and etc. And you need to be somehow a child, and you don't need to think like and have barriers, some barriers, you know, obstacles. You just need to be creative and need to understand your plans, and then your imagination will really lead you to real innovation step in your products. We work on that. There is a mechanism called TRIS from Altschuler, and I practiced TRIS for several years when I was in the university as a volunteer for patent law firms, and then I proceed practicing these methods with my team, with the investors, and all people that I work with. Okay, next slide, please. And here I will just show you, you see that this is the year Apple received their patent in 2013 for deep learning, machine learning prediction. And here, this is the claim, this is the formula from the patent. And they have very short claim number 1, with the 5 steps only. And there are the important things that I highlighted. And on the next slide, I don't want to read this. You will just understand why. The next slide, please. Microsoft received patent in deep learning for machine learning prediction road, same technology, but 4 years later, 2017. And red lines are the lines that Microsoft added during examinations. When you apply for the patent, when they applied for the patent, they had just black text. You see that? It can be compared with the scope of right that Apple applied and received earlier. But Microsoft was late in this area, and they needed to narrow their rights. And you see the difference between these. So they got a very narrow patent. They added too many things. And in order not to infringe the rights, other companies just need to avoid something or make different step. And it's easily to do with Microsoft patent, but not with Apple patent. I hope you understand what I mean here, because that can be a separate discussion for those who really wants to know more. But I hope that this quick discussion and example will help understanding. Okay, I watch my time. Next slide, please. So, and as everything in our world, we need to bring the system approach. We have preventive, proactive measures. You need to monitor market, and you need to do market analysis, competitive analysis. You need to do patenting analysis of your competitors and others' rights, and you need then return to your development, change or proceed developing. But you need to make sure that there are no problems. And they can be active measures and reactive measures. Active measures mean that you are on the way and you have policies, you have plans to implement. Reactive measures means that once you get claim, for example, or you are in the situation when someone proceed with unfair competition, or they posted false advertisement on Facebook or somewhere else, and what to do. So what if they just stole your property and use for their purpose? That means that you are on the way with reactive measures. You need to have plan what to do, because not every time you are prepared. That's normal. And your people, your employees need also understand what to do. So every step can be on record. And if there is ongoing lawsuit or further lawsuit will go, here you need to be very careful. Next slide, please. So when do I need to start? Right now. So if you have startup, please take your time and have all your efforts to think about intellectual property, preventive risk management, think about getting maximum amount of rights in all territories where you want to do this. And you need to develop technologies and think about competitors, because competitors really do not sleep. They watch. They watch for everyone. So that's all on my side. Thank you very much. I can speak a lot on multiple topics, and I hope that you enjoyed and have some insights from me, and that will be useful for you. Thank you.
Nadia, thank you so much. That was a fantastic and very enlightening discussion, and I will think about smells completely differently from now on.
Good.
So we have a few questions actually from the audience. I'd like to ask a couple of them for you. So the first one is this: what are the main problems specifically with copyright for startups that you can remember from your experience?
Okay, very good question. So we a little bit discussed this during my presentation. You need to think about third parties' rights when you create your product. Sometimes people answered question like that. The question is, where did you get this program code? I got it from the forum. I don't remember which one, but it was from the source from internet. That's really bad. No, never do that, please. That's really awful. So you need to think about your own copyright, your own code. And it was the story that some Chinese guys just stole the code with the comments in different language, and they didn't, and they even copied errors from the program. So that was two things. They copied errors and they copied comments from the company, and that was easy to prove that this infringement. But be careful with the copyright. There are so many things, and for example, you cannot really have two exclusive rights. But sometimes companies really think that they can. I don't know why, but there is only one exclusive right, and you can really license. You have non-exclusive licenses, but exclusive license is only one. Okay, so okay, will it help?
I think so. That was very helpful. There's one more question for you here, which is if we receive a C&D letter saying that we infringe someone else's patent rights, what to do if we even have not been aware of their technology?
Okay, thank you very much. That's a very good question. That is about different languages and patents, right? Do you remember that I told you about programmers? They can use C++, Java, or assembler, or Python, or any other code languages. So, but the idea can be patented by any of them. And regardless of the fact that company created this work product by themselves in different language, they still be possible infringement. And what to do? Better to be knowledgeable about this, and uh, don't don't hurry up. Have advice from the company which had experience with this, and you will need to prepare analysis, non-infringement analysis, and then you will need to prepare for negotiations and dialogue with the company, because that's very hard. That's you cannot touch the code, and you will need to explain the reasons, arguments, and that is the challenge, I can tell you.
Got it. Nadia, again, thank you so much. I think there's one more question here, but looks like this one's for me. So which countries offer a startup visa? It's a great question. The answer is I don't know all of the countries off the top of my head. However, it's a great question in that we should first start by thinking about the countries which don't offer a startup visa. And I think the first one to think about is the United States. So in the United States, if a founder wants to come to the US, there are several different types of visa categories that a founder might want to look at. One would be the extraordinary ability visa, whereby the founder shows that he or she has reached the very top of his or her field in business or the sciences. Another category would be the L1 visa, which is for intra-company transferees. Like I had said earlier, if you have a company and you've already established it and it's already active and doing business and has employees and the like somewhere else, and you want to open up a subsidiary in the United States, there is an opportunity to do that. For citizens of certain countries, but not all countries, there's what's known as the E2 visa, which is an investor visa, which allows individuals to come to the United States if they intend to invest their own capital into a new business that they then intend to run and supervise and direct. What's missing in the United States, however, is what happens if you are a young founder who hasn't necessarily reached the point of being extraordinary ability or being an executive or manager, but you have a great business, a great young startup, or a great business idea, and you have US investors who are willing to invest sufficient capital into your business. This is a type of visa opportunity that the Obama administration had actually tried to push through, calling it the startup visa. It then was axed We'll see if in the next 4 years with the new administration, if this will change. I truly hope that it does. I think it's very reasonable. Switzerland also does not have a startup visa. Switzerland also has visa opportunities either for investors who are looking to start new businesses and bring their own financial capital into the country, or for executives who are able to establish also that they have reached the top of their career and that there is a real need for them in Switzerland. These categories actually can be used, obviously, by founders, especially founders who are working in highly technical fields, because the more technical you are, the more specialized your work is, the more rare you become. That being said, in some other countries, there are actual startup visas. So Singapore has one, Italy has it, France has it, Germany has it. In these countries, if you have about 50,000 euros, give or take, and a good business plan, there is an opportunity to go ahead and start your business in those countries. So the startup visa does exist. Sometimes it's a great idea. Sometimes it's not available. I wouldn't let that be a deterring factor. I think that where there's a will, there's a way in terms of doing business in various jurisdictions. So I would recommend to take a look at it holistically. One more point that I wanted to make before we move on, just to remind everyone out there that Nadia and I are not giving any legal advice or tax advice during this webinar. This is for information and educational purposes only, and obviously we very much encourage all of you out there, if you require such services, to go forth and seek out counsel and have an actual engagement with that counsel. So just wanted to make sure we have that disclaimer out there. Nadia, again, thank you so much for joining us today. This was fantastic.
Thank
It
you,
was a real
Katya.
pleasure.
Thank you, Katya, for your presentation as well. It was very good. Thank you.
Thank you. Let's move on to our next slide. Here we have some information for all of you out there. So for starters, SIT Academy is offering a cybersecurity online course. It's approximately 15 hours to complete. The price is $350, but you can obtain 20% off if you can actually write down and remember that promo code that's here on the bottom left-hand side of your screen. Or better yet, just visit promo.sit.org/Academy Cybersecurity Online Course. Or if you have any questions, just email events@sit.org and they will be sure to direct you to the right place. Through this course, you will learn everything you need to safeguard your company against emerging cyber threats and be able to select the right tech solution for your company and keep business operations safe. Let's move on, please. Thank you. Now, another reminder and update, we have our next SIT STAR contest for 2021. It will be on February 10th, 2021 at 8 a.m. You will have the opportunity to solve up to 12 challenges in algorithmic programming in just 4 hours and have the chance to win surprise gifts from Switzerland and a chance to study at SIT with a full scholarship. So to learn more and to register, please visit sit.org/contests/star2021. Let's move on. And thank you all very much. This has been an absolute pleasure. I hope it has been entertaining and educational for everyone out there. Should you have any questions, comments, thoughts, ideas, concerns, please write to events@sit.org. Have a wonderful day.